Welcome, everyone, and thank you for dedicating your time to learn and discuss how South Carolina can successfully implement its legislation to raise the age of juvenile court jurisdiction. My name is Jeree Thomas. I am the Policy Director with the Campaign for Youth Justice in Washington, D.C. We are a national initiative dedicated to the removal of youth under 18 from adult courts, jails, and prisons. We believe that youth should be served in developmentally appropriate ways. And if there is a tough decision to transfer a youth to the adult system after other services have been exhausted, it should be well-trained family court judges making those decisions. Groups like the National Sheriff's Association, the Council of Juvenile Correctional Administrators, and the National Association of Counties, among many others, share this belief. Having some trouble with my screen. Let's see here. There we go. Today, you will hear briefly about the national context for raising the age of juvenile court jurisdiction. You will hear from Josh Rovner at the Sensing Project about South Carolina's context, and most importantly, the data that will help you and other system stakeholders forecast what to expect upon implementation. Finally, you will hear from Judge George Timberlake, a retired Illinois judge who was a leader during his state's implementation of their Raise the Age law. He will talk about how the law impacted the juvenile justice system in his state. We hope to leave approximately 15 minutes or so for questions and discussion at the end. However, please feel free to type your questions into the webinar chat box at any point during the presentation. Let us know what types of information and supports would be helpful in your jurisdiction moving forward. In 2005, when the Campaign for Youth Justice launched, there were 14 states automatically treating all 16 and our 17-year-olds as adults without having passed laws to raise the age of juvenile court jurisdiction. As of this month, 10 of those states have passed laws to raise the age of juvenile court jurisdiction. And those states include, as you see on the map, Connecticut, Massachusetts, Illinois, Mississippi, New Hampshire, Louisiana, South Carolina, New York, North Carolina, and Missouri. 5 of these states are in the process of implementation: Louisiana, New York, North Carolina, South Carolina, as you know, and Missouri. And there finally are 4 states that have not yet passed legislation. And those states are Georgia, Michigan, Texas, and Wisconsin. I will also note that in many of the states that recently raised the age to 18, we are now seeing legislative efforts to raise the age above 18. Specifically, we've seen these efforts in Connecticut and Massachusetts, as well as an effort in Illinois to raise the age to 21 for young adults charged with misdemeanor offenses. This year, Vermont became the first state in the country to pass legislation to raise the age of juvenile court jurisdiction to include 18 and 19-year-olds by the year 2022. In 2017, the Justice Policy Institute released a report on how states have successfully implemented Raise the Age. They specifically highlight 7 strategies that states utilized both before and after implementation to ensure a smooth transition. The first strategy is to expand the use of diversion, both pre-arrest and pre-adjudication. The second strategy is to make probation and aftercare approaches more effective by using tools like a graduated response grid and by not detaining youth solely on technical probation violations. The third strategy is to address young people's mental health needs outside of the deep end of the system, specifically by investing in more community-based mental health services. Fourth, reduce the use of pretrial detention by implementing practices like the Juvenile Detention Alternative Initiative, such as adopting an objective screening tool. The fifth strategy is to reduce reliance on facilities and focus on community-based approaches by investing in community-based services, shortening lengths of stay for young people who are incarcerated, prohibiting the commitment of young people for certain behaviors, and reallocating money from the closure of units or entire facilities back into counties in order to build out continuums of services within a young person's community. The sixth strategy is to keep young people safe by complying with the Prison Rape Elimination Act's requirement of sight and sound separation when a young person is in an adult facility. States are also complying with the Prison Rape Elimination Act by prohibiting the placement of youth under 18 in adult facilities as well. Finally, improve juvenile justice system's management of resources and strengthen strategies to serve young people more effectively, specifically by using risk and needs assessments and structured decision-making instruments more effectively. What they found was that utilizing these strategies resulted in states spending much less money than what was projected to implement the law. So in the first generation of raise the age states that collect data, Connecticut, Illinois, and Massachusetts specifically, juvenile crime and juvenile confinement decreased at a faster rate than the national average. So the national juvenile violent crime rate decreased by 29% between the years 2005 and 2015. But in those three states that implemented raise the age, Massachusetts, Connecticut, and Illinois specifically, we saw a 33% decrease, a 66% decrease, and a 69% decrease in the violent crime rate over that same time period. In fact, some states started closing youth facilities after raising the age because the estimated increase of youth never materialized in the juvenile justice system, which of course resulted in potential cost savings and an opportunity to reinvest some of that money into serving youth in their communities. Judge Timberlake will be able to share more about what happened in Illinois, but you will also receive a copy of this report to learn more about these strategies following this webinar. So as you know, in 2016, South Carolina's legislature unanimously passed S 916 to raise the age of juvenile court jurisdiction. The law excludes 17-year-olds charged with Class A through D felonies, and the law's full implementation is contingent on the legislature providing necessary funding for DJJ to implement the law during the 2019 legislative session coming up. Full implementation is scheduled for July 2019. Last year, DJJ submitted a budget proposal around their raise the age projections, and they proposed a request of additional $55 million to implement raise the age, assuming that there's no policy or practical changes to implement some of the strategies that I mentioned a couple minutes ago. So to dig deeper into the numbers, I will turn it over to Josh Rovner, Senior Advocacy Associate at the Sentencing Project, to share more details.
Thanks so much, Jury, and really thank you to everyone who's joining us today. This is Josh Rovner. I'm the Senior Advocacy Associate at the Sentencing Project in Washington, D.C. We're a research-based advocacy organization that promotes reforms in sentencing policy, addresses unjust racial disparities in practices, and advocates for alternatives to incarceration. Now, other than a few corny jokes, almost everything in today's presentation came from the Department of Juvenile Justice, whose staff and leadership have been eager to share the story I'm about to tell. These numbers are open secrets, mostly available on DJJ's website. I just put the relevant numbers in graph form. When I asked for it, the lead statistician at DJJ provided more detailed information. For example, listing all the specific charges instead of a top 10 list. None of this, I'm thankful to say, required a FOIA request. DJJ has really been a great partner in this. So while Jeree just gave an outstanding overview of the big picture, and Judge Timberlake will tell you about what happened in Illinois, my slides are almost entirely about South Carolina. What you're about to hear is that the juvenile justice system is smaller than it has been in years, though I don't need to tell you that the system is obviously burdened by huge responsibilities. That said, there's now elbow room that did not exist until recently. And the numbers also show that South Carolina can lock up vastly fewer kids every day through very modest decisions that may be within your power to implement and are certainly in your purview to encourage. Next, please. In talking about a smaller system, let's start here. There's been a downward trend in juvenile arrests by year. These are the arrests of 12 to 16-year-olds in South Carolina split into two categories. The brown line shows the arrests for the FBI's uniform crime reporting categories of arrests, and the blue line is all other arrests. As you can see, the most common reasons that youth are arrested show up in the blue line. That line includes simple assaults, disorderly conduct, shoplifting, and drug violations. The brown line is mostly comprised of larceny arrests, but that's also where you'd find violent offenses. The important thing is the trend, both for the UCR offenses, which are generally more serious, and for all other arrests, the trend is quite clear. Fewer kids in South Carolina are getting arrested. So on the next slide, you'll see a graph that combines UCR arrests with the others. When all those events are combined, you can see an upward trend in the 1990s, roughly plateauing for 10 years, and then a steady decline since 2005. Since 2005, youth arrests have fallen by more than half. That's a really good news story, and I suspect that some of you on the call can take pride in what's shown here. When things change a little bit in the same direction every year for a decade, that adds up to a big change. Many of you have served as judges or in other public serving capacities for decades. So this may be a story that you already know, but it's still worth repeating often. This isn't just a local story. 42 out of 46 counties have seen at least some decline. 24 counties have seen at least 50% fewer arrests, and that list includes all 5 of the largest counties. Now, let's admit that this number is never going to reach 0. Think back to your own high school years and the reckless decisions you might have made that could have gotten you or your friends arrested. Teenagers struggle managing their emotions, resisting peer pressure, and predicting and responding to the consequences of their actions. That's normal adolescent behavior, normal adolescent development. The challenge for all of us is how to minimize the short and long-term impacts of conflicts with the law, both with an eye toward responsible budgeting and, more importantly, toward positive outcomes for the kids and their families. On the next slide, you'll see the drop in arrests, still shown in blue, and how it has rippled through the system. The gray bars are the referrals to DJJ and to the solicitors. You can see we have more recent counts on referrals. There's consistently a gap in the number of youth arrested and the number of referrals. And that's because many different actors can make referrals to the solicitors, not just law enforcement. Going back to 2002, the downward trend is a remarkable success story. On the next slide, you see the big picture. Over the last decade, there's been a 53% decline in arrests, 45% fewer referrals, 28% fewer kids sent to detention, 29% fewer kids being prosecuted. The number of kids receiving probation has gone down 33%. Residential evaluations down 42%. Commitment down 47%. And that's really good news worth celebrating. So the immediate question we're interested in is the impact of adding 17-year-olds into the juvenile justice system. It's not a small impact, and I'm not here to tell you otherwise. Can we just keep it on the sort of intro slide? Yeah, that one. That said, in the other states that have undertaken this reform, the trends I just showed you continued unabated. For example, Connecticut, which has the longest experience with Raise the Age, saw saw 20% fewer delinquency referrals in its juvenile courts in 2016 than 2013, before and after implementation. Mississippi moved most of its 17-year-old felonies into the juvenile courts in the middle of 2011. Mississippi saw a 13% drop in the referrals to juvenile courts in the 3 years after implementation compared to the 3 years before implementation. In short, the downward trends that I just shared for South Carolina aren't unique to your state. The national juvenile arrest rate has fallen by more than half over the last 10 years, for which there are data. And now we can move on, because I want to continue the story by returning to the graph from earlier, the arrests of South Carolina's 12 to 16-year-olds, and it's been cut in half since 2005. So the impact of adding 17-year-olds is going to be less than it would be if the system were larger. This pattern is obviously going to look different in each circuit, in each county, but recall that between 2005 and 15, the number of arrests fell in 42 out of 46 counties. So this slide, with the orange bars added on top, shows the impact and how consistent the relationship is over time. The blue bars are the 12 to 16-year-olds arrests, and then I added in orange the 17-year-olds arrests. So the height of the bar in each year is the number of 12 to 17-year-olds arrests. In a typical year, 17-year-olds added roughly 40% to each year's total. What's remarkable is the ways that the overall drops have made this a manageable change. Can everyone focus on the red dotted line on the right side of the screen for a moment? It's pretty small, but it's there, halfway up the screen on the right. And I'll pretend that you're all nodding because I can see you through your computers. So the next slide. Thank you. The next slide shows that there were fewer arrests of 12 to 17-year-olds in 2005 for 12 to 17-year-olds in 2005 than the number of arrests of 12 to 16-year-olds as recently as 2009. Now, SLED has declined to provide us with arrest data for 2016 and 17, so this is the most recent that we have. This is how that good news from earlier makes raising the age more manageable than ever in the immediate term. But let's turn to what 17-year-olds offending looks like, because this hardly gives a full picture of the impact. Under Section 10, we're going to move on. Under Section 10 of the Raise the Age Law, courts administration was tasked with collecting relevant data and statistics and reporting it to the General Assembly. Here's that data. They provided it as a spreadsheet, and I turned it into bar graphs. This is the essence of what they found. Overwhelmingly, when 17-year-olds have been going to the criminal justice system, it's for misdemeanors. Even better, it's the lowest class of misdemeanors. So I'm really appreciative of the legislature for creating the conditions where these data are public. Without the Raise the Age law, we wouldn't have known this. Again, about 1 in 5 are for felonies. That's the same ratio as with 12 to 16-year-olds. However, Class A through D felonies are going to remain in the adult system, so the new 17-year-olds in your courts overwhelmingly will be there for misdemeanors. Across the bottom, you can see the classes of warrants, starting with felonies, Class A through F, followed by the misdemeanors, Class A through C, then unclassified misdemeanors, which is the largest bar. Now, we only have 1 year's worth of data, so I don't know if this is typical, but I have no reason to doubt that it is. I've already shared the good news, and I'm going to switch to even better news while also asking a few questions about what's hiding in these numbers. Next slide. There's even more room for improvement. This is a moment of great opportunity. If you'd like, you can think of this section as why you're working so hard. Why is it that even though half as many young people are getting arrested as 10 years ago, why is the detention center still so full? Why are your courts still so busy? Next slide, please. I started with the drop in arrests and the drop in referrals. That remains the central piece of good news revealed in the data. But let's look at the gap in the number of youth taken into custody and the number of referrals. That's because many different actors can make referrals to the solicitors, not just law enforcement. Statewide, about 40% of referrals to the solicitors, that's more than 1 in 3, do not start with law enforcement. And let me add that proportion is growing. 5 years ago, it was 36% of referrals. 10 years ago, it was 25% of referrals. In some counties, that number is well over 90%. At the low end, there are counties where the gap is roughly 20%. So question number one is how to refer fewer kids into the juvenile justice system when their referral is not precipitated by an arrest. Who else is making these referrals? And is the justice system the right place to deal with these issues? Next slide, after a couple extra clicks. Thanks. So let's move a little deeper into the system, the use of detention. The gray bars are the use of referrals, that's the total number of referrals by year, and the purple line is the number of young people in detention graphed on a different scale. For a long time, fewer referrals meant fewer young people in detention. I think it really makes sense as a correlated relationship for obvious reasons. Next slide, though, because let's just take a look at this decade, because you can also see how that relationship has fallen apart since 2011. The gray bars show referrals, referrals fell by 25%, which is wonderful. But the number of kids in detention actually increased by 4%. That's what's shown in the purple line. So question number two, why are a greater percentage of referrals winding up in detention than ever? And that brings up question three on the next slide. Who is detained? That's not a rhetorical question because DJJ's annual statistical report answers it. It's another gap I want to highlight, the difference between the number of young people in detention and the number of serious or violent referrals. We know that even short stays in detention have negative outcomes, behavioral health, education, repeat offending. And so it's troubling that 60% of the youth in South Carolina's detention centers have not been charged with a serious or violent offense. It's not cost effective. It's going to tax the staff of the detention centers. It's likely to increase recidivism, and it's a real opportunity for reform. The present budget for the detention center is roughly $3.6 million. That works out to more than $1,000 per detained young person over the course of the year. And that's just the fiscal impact. Next, please. $1,000 per detained young person. And yet the top single reason that young people are detained is for administrative reasons. It's 30% of all detentions, roughly 1,000 kids last year. In some years, there are roughly as many kids detained for administrative reasons as for serious or violent offenses. This is not only a waste of money, it's setting up the juvenile detention center as a crime school, putting low-level offenders in contact with the serious ones. And we still haven't accounted for the last 30%, comprised of young people who aren't held for administrative reasons, nor for a serious or violent offense. Those are the status offenders, probation violations, thefts, not things that are risks to public safety. Last year, there were as many kids detained for violating probation for a misdemeanor as there were kids detained for second-degree assault and battery. So let's look at the kids in detention from level of offense. You can see from the graph that roughly 1/3 of the detainees are there for felonies, 1/3 for misdemeanors, and 1/3 for administrative reasons. The exact numbers are shown on the slide. More specifically, 37% for felonies, 30% for administrative reasons, most commonly pickup orders, bench warrants, and judicially detained, 28% for misdemeanors, 4% for status offenses, and 1% for contempt of court. So what this shows you is that only removing the status offenders from the detention center, which I support, by the way, is not going to make a big difference in the detention center's capacity. It's just not that big a piece of the pie. Next, please. Here's a closer look at the number per year. About 1,000 administrative detentions every year this decade, though there's a couple years that the total was about 25% more than that. I'm definitely eager to hear from those judges who have limited their use of administrative detentions and how it's worked so far. I'd like to know more about how this might be an opportunity for reform. Next, please. It's important to recognize that the kids in the detention center aren't being sent there because they are a threat to the public. 1/3 of them are there for less than 3 days. 2/3 of them are there for less than a week. That's not an image of a child that you can't trust at home unless the staff is absolutely exceptional at turning these kids around. Now, why am I opposed to detaining kids, even for short periods of time? 1. Detention can increase recidivism. Putting kids in detention changes their peer group, putting them in contact with more young people who have committed offenses and away from the average teenager. 2. Young people who are detained at intake are more likely to be committed post-adjudication, even after controlling for everything you'd want to control for. 3. There's no evidence that increasing juvenile detention decreases crime at the community level. 4. Young people with behavioral health problems get worse in detention, not better. It puts them at a greater risk of self-harm. 5. It interrupts education. 6. It makes it harder for young people to attain employment later. 7. It's really expensive. 8. Youth of color are disproportionately detained. So with that, I'm going to turn to the use of community and residential evaluations on the next slide. This is another good news story. Largely because of the declines in referrals, there are fewer young people being sent to evaluation. And I'm especially pleased with what's being shown here. This graph shows residential evaluations by year and community evaluations by year. The red bars are residential evaluations. It wasn't very long ago that more than 2,000 young people a year were being sent to the residential eval centers. And now there's about 1,000. Again, that's the red bars. The purple bars show the use of community evaluations, a number that hovers around 900 per year and has for a long time. Combined, that means that a greater proportion of evaluations are taking place in the community. That's what the blue line shows. Back in 2000, 20% of evaluations were community evaluations, and 80% were residential. Now, slightly half of evaluations are community-based. What these numbers suggest to me, admittedly, sitting at a desk in Washington, D.C., is that the capacity for community evaluation is limited, and more resources could be directed toward hiring community-based evaluators, which would be better for the kids and their communities for all the reasons I discussed in discussing the dangers of detention. Next, please. This graph shows the differences by judicial circuit. And I understand if you're just going to look at your circuit and compare it to the statewide average as I'm talking. The red bar on the left is the statewide average, 54%. And the blue bars are the percentages in each circuit of all evaluations that are residential evaluations. The use of residential evaluation ranges from a high of about 70% in the first and second circuits to a low of 18% in the 14th circuit. There's really very little variation except at the low end in the 3rd and 14th circuits. The available data can also be analyzed by level of offense to see how frequently judicial circuits utilize residential evaluations for status offenses, for misdemeanors, and for felonies. That's not what's shown here. Statewide, judges are modestly more likely to order residential evaluations for more serious offenses. Less than half of status offense adjudications result in residential evaluations. Exactly half of misdemeanor evaluations result in residential evaluations, and 2/3 of felony adjudications result in residential evaluations. Next, please. Because this slide shows the differences by judicial circuit in the use of residential evaluation for status offenses. Again, this is status offense adjudications alone. Circuits demonstrate large variety in the use of residential evaluation for status offenses. Overall, 47% of status offense adjudications resulting in an evaluation take place in a residential evaluation center. This ranges from at least 70% in the 2nd, 1st, and 15th circuits to a low of under 15% in the 12th, 3rd, and 14th circuits. So there is a great deal of discretion in this process. Next, please. Finally, we turn to final and suspended commitments. As with other data points, there has been tremendous progress and fewer children receiving suspended and final commitments. The average daily population behind the fence at BRRC continues to shrink as well. But a closer look reveals even more room for progress. The largest drivers of long-term juvenile incarceration are not serious or violent offenses. The 4 most common reasons that children in South Carolina receive suspended or final commitments is probation violations. The third-degree assault and battery ranks number 5. 2 of the top 3 reasons are probation violations, when the underlying charge was a misdemeanor or a status offense. And so question 4 must ask why there are children being locked up for violating probation when the underlying charge was not felonious or criminal. Next, please. So let me repeat what I've said so far. First, understand that most 17-year-old offending is low level. Second, a large proportion of cases in the juvenile system do not stem from an arrest. In particular, status offenses, mundane, adolescent behavior are clogging the system. Third, most young people in the detention center have not been accused of a serious or violent offense. Instead, they are often being held for administrative reasons. Fourth, the relative growth of community-based evaluation is a positive trend that I hope continues. Fifth, the leading cause of commitment is probation violations, not a new offense. Each of these observations points to the ability of the juvenile system to shrink farther, to lighten the load on county solicitors and judges and the staff at the secure facilities. And all of these changes can further enhance public safety and continue the great success and progress that the state has seen so far. I have a couple of slides that I'm not going to linger on too long. So the first one, next one please. This goes over the DJJ budget over the last decade or so. The total budget is $120 million, and this really shows just how much money is being spent, first on the divisions and subdivisions under $10 million. Let's go to the next slide. And these are the divisions whose budgets are over $10 million a year. So you can see the most expensive parts of the system are incarceration. So we know the money exists. We just want to see it allocated in smart ways. I'm not going to linger on this, but we share the slides and record the webinars so that you can look more closely at exactly this kind of thing if you'd like to. Next is a concluding slide about how juvenile offending has fallen sharply and how this has provided great space in the system, but there's further room for improvement, decreasing referrals to DJJ, prosecuting a smaller percentage of referrals, decreasing the use of detention and residential evaluation, and only using commitment as a final resort, especially eliminating it for status offenses and low-level offenses. So one last slide with my email address on there, though you may have it otherwise. And then I'll hand over the microphone to Judge Timberlake. I really want to emphasize that this presentation was about statewide data. Your part of the state is unique. Thankfully, I have county-by-county data. It's just not what I was doing today. So, if you'd like to know what the data show for your counties, for your judicial circuits, how that compares to the statewide average or how it compares to neighboring counties, I can do that. South Carolina, I've really been pleased to see, is transparent with its data and has been eager to provide it to me. I now have numerous spreadsheets that I'm eager to share with anyone who wants to take a look at them to answer more questions about what I've learned. With that, though, I'd really like to hand it over to Judge Timberlake to talk about his experience as a judge in Illinois after Raise the Age and before Raise the Age took place in his state. Thank you, everyone.
Thank you, Josh. Ladies and gentlemen, I'm pleased to be a part of this discussion, and I am struck by the diversity of states who have already raised the age of juvenile court jurisdiction. I'm also struck by the diversity of those states who have not done so. Throughout the country, individual states have looked at the data that you just saw for their individual states and jurisdictions and have come to essentially the same conclusions. I have recently, like this month, retired as chairman of the Federal Advisory Committee on Juvenile Justice. And in that capacity, I talked with states across the country and visited many of them who were going through these same kinds of questions. So I guess what I'm trying to say is South Carolina is different than every other state, but every other state is different from you. Nonetheless, they've all, or many of them, most of them, have come to the same conclusion that those young people involved in juvenile court certainly deserve the same kind of data-driven, analytical approach to how our systems work or don't work. South Carolina has taken one specific step similar to Illinois, and that is to raise the age of jurisdiction for non-felony offenses. Illinois did exactly that. However, in 2010, the lower jurisdictional age applied only to misdemeanors, and the legislation required the Illinois Juvenile Justice Commission, which I chair, to report on the effects of that change and to indicate whether what that analysis presented for further raising the age for felonies. To that end, we created a report and entitled "Raising the Age of Juvenile Court Jurisdiction." It is available if you would Google Illinois Juvenile Justice Commission, go to Publications, go to Reports, and with that title, "Raising the Age of Juvenile Court Jurisdiction." Now, that's a 76-page report, and I'm certainly not going to spend the time today to try to describe all of that. But much of what Josh has just presented is reflective of what happened in Illinois, not just about the change, but about the general decline in juvenile court arrests, as well as referrals and prosecutions. I can tell you that the idea of raising the age for felonies was not popular in all circles, and I'm sure you have met the same kind of resistance in places. So let me give you an idea of what our experience was. And that experience was that in one very large urban county in Illinois, which you may have visited in the past, the probation department commissioned a study by a respected researcher, a person known in the juvenile justice research community, to predict the effect on that county's probation department. The result of that was the researcher suggested that it would take $70 million for that single county to accommodate 17-year-olds into the juvenile justice system. Now, I don't know what data was provided by that department to the researcher. I don't know what access she had to the administrative workings in that county, but $70 million is a lot of money, even in a state of 13 million people. The fact is that nothing happened. There was no increase in that department's budget necessitated by this single change. There was no crashing of the probation department, as was predicted, without that amount of money. And it was a totally non-event to add that additional caseload. Now, does that mean it wasn't without effects on probation departments, law enforcement, and the court system? Of course not. There was change, but the change, which was occasioned by this change in age jurisdiction, turned out to be a good thing. What do I mean by that? The development of greater diversionary practices within our police departments the greater use of diversion at all levels, from law enforcement, probation, the court system, prosecutors, all of those things, which have always been available, and particularly in Illinois for over 20 years, suddenly came into vogue, I suppose, as effective responses to juvenile crime. That reduced caseload, simply enough. It kept kids out of the justice system, even as crime was declining. That allowed flexibility for probation managers, for chiefs of police, for everyone in the court system to step back and say, what else could we do other than bringing kids into our system? Why? Well, on the one hand, to reduce caseload, to reduce costs, but on the other, because it's the right thing to do. The science that has developed in this century is extraordinarily clear that involvement in the justice system, particularly when it includes incarceration, is a predictor of higher criminal activity among those kids. Lesser outcomes and what might be achieved, rather than the evidence-based practices that we all have learned about now, and from the data of effectiveness of those evidence-based practices, if a kid is brought in. The point is, some kind of behavioral intervention, mental health assessment and treatment, trauma-informed screening and applicable therapies approach, it reduces recidivism. It reduces crime. And the earlier we can get at that, before the justice system has to be involved, the better. Nobody here is arguing that we don't need all of the components of the justice system which we have now. What we would consider is, what is the effect of our past system approaches to young people, and how much better we might be off as a society, both for greater public safety and lower budgets. We discovered that in Illinois, and I have to say then, since that time, since 2010, when we issued this report, and since the age now includes felony arrest, our whole system is smaller. In 2006, we created the Department of Juvenile Justice, split it off from the Adult Department of Corrections. At that time, there were 1,300 kids inside, 1,700 kids on probation. Today, the average daily population for those inside DJJ is less than 400. The probation caseload has dropped from 1,700 to 7. The point being, there have been massive changes in our justice systems in this country in the last 20 years for the better. Things are better today than they were in the 90s and the fear of super predator kids. You must understand that some people will resist this change for all kinds of possibilities, probabilities. But the truth is that the changes that have happened in Illinois have been for the better all the way around. And no one's department has crashed. So what do? Law enforcement is vastly more prone to using station adjustments, a diversionary technique, than to actually make referrals. In the court system, state's attorneys are more likely to use community-based alternatives for low-level crime, certainly, but in other cases for very serious crime. That includes not only community-based organizations, but also community approaches such as restorative justice. I can tell you that today in Cook County, Illinois, in Chicago, there is a restorative justice community court sanctioned by the chief judge of Cook County and operated, at least led by, a juvenile court judge from that same jurisdiction. Crimes in North Lawndale, Chicago, Illinois, a high crime, distinctly African American community, are now being handled by the community itself in that community court. Lower cost, less reliance on court resources, and in fact, we don't have results yet, but it so far looks like it's going to significantly reduce the involvement of the governmental court system on the lives of young people in that jurisdiction. I don't live in Cook County. Like South Carolina, Illinois is dominated by a few very large jurisdictions, but the vast majority of the geography is, as the Second Circuit, where I serve, very rural, sparsely populated, lower resources than anywhere else in the state. So why would we spend money on not only detention, which cost counties in our state, not the state itself, and prison, which currently costs about $160,000 a year per kid? Why would we do that when there are more effective approaches to be had? I think it's absolutely necessary that as court system members, we take a hard look at the effect of our practices. What does it mean in terms of public safety? What does it mean in terms of positive outcomes for those inside the system? And what does it cost? I think we can do that. One of those approaches is just what's going on now. The idea of detaining status offenders and the administrative category is somewhat ingrained in all of us, I think. You know, you issue an order, a kid does not comply, you want that kid to comply. Maybe your first instinct is to reach out and contact that kid. Maybe it is to simply sign a warrant, say, go get him, I want him. I don't think that's always the wisest thing to do, particularly when you see the data that shows, as in South Carolina, Illinois' population of those who are status offenders, probation violators, those held in contempt of court, is extraordinarily high compared to the number of young people who are legitimately believed to be a threat to public safety. The standard I think we all have to adopt is simply this when it comes to those kinds of detention decisions, both at first appearance as well as subsequently in violation situations. And that is, we should detain those who frighten us, who frighten the public, who are a genuine risk to the safety and well-being of all our citizens. Those who frighten us are legitimately subject to detention. Those who merely anger us are not. Sometimes, and all of you who have served as in juvenile court as judges know that sometimes you have a kid and you just can't quite get there with the kid. Adolescent development, brain development in young people really teaches us that many times kids are obstructive, not out of a reason of disrespect or genuine animus towards the person on the bench. Rather it is they're just not ready. So sometimes you just have to wait for it. Being angry at a kid is not an appropriate standard for detention, nor for sentencing to state incarceration. At least that's my opinion. And what has happened in this state, in Illinois, is that we're better today for public safety. We're better today for positive outcomes for young people. We're better today because we spend less money on our court system and the public is safer. That should be our goal. And I think that's that is what drives these reforms in juvenile justice and certainly in raising the age of jurisdiction. There are brave states who are attempting to raise it even further to recognize the science that we have available for ourselves and to recognize that science says the plasticity of the human brain continues until mid-20s and after. I'm old, so I don't know that mine's still very plastic, but for those kids, science tells us today that older young people, those older than 17, 18, 19, are just as capable of responding to the evidence-based approaches that we've all discussed. And so perhaps the future is going to take us even further along this road. In South Carolina, the goal, however, is to make this one step, which, at least in Illinois' experience, is highly unlikely to change your system except for the better. We'd appreciate questions. That's the section at which we've come to now.
Yes, thank you, Judge Timberlake. Yeah, we have about 10 minutes or so. So if anyone has any questions, please do feel free to ask them.
So this is Josh, and I think I'd like to direct a question to the judge to ask what arguments you heard in Illinois when Raise the Age was being debated there and in the immediate months after implementation.
Yeah, one of the ones most ardently presented was that if we raise the age of jurisdiction to include 17-year-olds, then that would be a detriment to younger people. So if you have a 12-year-old and a 17-year-old in the same detention facility, there was a fear that there was going to be an inordinate amount of influence on the younger person towards from the older. Knowing detention practices, it seems to me that kind of an interaction was highly unlikely. Detention is a profession, same as is probation, law enforcement, judging. And at least the facilities that I have managed as chief judge, as well as the facilities I've visited in Illinois and around the country, is that those individuals working there are completely capable of, for one thing, separating that age range, 12 to 17, or to managing it in such a way that it's normal. 12-year-olds likely got a 17-year-old brother. That sort of an approach. There's no inherent danger that a younger child is going to be recruited by the older child to do something dastardly. So that was one that was often used, and I think that the fear of that certainly has not materialized in any way, as you all have said today. Crime rate's going down, the system is becoming smaller, and the public is safer for it. And that's and Josh, the other part of that is there's just not, that conversation ended several years ago. The system accommodated that age range, and nothing bad happened. So one of the other things I forgot to mention to the judges here is one of the factors in raising the age for felonies as well as misdemeanors was simply this. States have different transfer laws, but in Illinois, any crime by a juvenile can theoretically, legally, be transferred to adult court. Of course, some of it is automatic, and we've recently severely limited the number of cases that are automatically transferred. But there is discretionary transfer in every case, for every kid, for every courtroom, for every judge. Have we seen a great increase in transfers? No, quite the opposite. Transfers have also declined. So a fear that you're going to lose control of or lose the opportunity to improve public safety simply doesn't exist when you consider that any case can be transferred. I don't know the law in South Carolina. I'd be happy to hear what it is in regard to transfer of children to adult court.
Thanks.
Yeah, thank you, Judge Timberlake. And while we're open for questions, I just wanted to also mention that you see the note on your screen. So the next opportunity to discuss implementation will actually be next week. So as a part of the work to successfully implement this law, the Campaign for Youth Justice and a number of stakeholders from across South Carolina have been talking and having conversations about what can be done in preparation for implementation in July of 2019. And so if anyone on this call is interested, you are welcome to join the conversation on Friday, October 5th at 2 p.m. As I mentioned, the call will include stakeholders from the Department of Juvenile Justice, solicitors, public defenders, advocates, and others who are coming together to think about how to start preparing now for next July. So please do reach out to me. My email is there to follow up. I will also follow up with this group and provide a copy of this presentation, as well as the reports mentioned earlier in the presentation. Well, are there any other questions before we close out? Okay. Well, if we don't have any questions, I think we could probably end a little early, but I want to say again, thank you all so much for attending. We hope that this is only the beginning of the conversation. We look forward to working with you all. Please do reach out to us if you'd like to talk more about how we could support your jurisdiction, if you'd like that data analysis or some additional information. Thank you again, and have a wonderful rest of your day. All right.